हो हो हा ती कालची गोष्ट आहे, आजच्या अपडेटेड गोष्ट आहे यांच्याकडे. एक मिनिट. हॅलो
हॅलो.
हा सर, माय व्हॉइस इज ऑडिबल?
येस येस सर.
ओके ओके सर.
माझा ऑडिबल आहे ना?
हो हो येतोय सर, आवाज येतो.
मी स्क्रीन बघतो.
हो सर.
पोस्ट डिसेबल्ड पार्टिसिपंट स्क्रीन शेअरिंग असं.
एकच मिनिट सर, एकच मिनिट. तुम्हाला होस्ट करतो, म्हणजे तुम्हाला शेअर करतो. हा सर, आता ट्राय करा सर.
हा ठीक.
हो दिसते सर स्क्रीन.
दिसते ना?
हो.
मग असंच ठेवा डिस्प्लेला आता?
हो असू दे सर. वाटलंच तर फुल स्क्रीन करता येईल का सर?
फुल स्क्रीन ना, एक मिनिट.
रेकॉर्डिंग पॉज करतो सर मी, परत चालू. Hello and welcome everyone. Vidya Pratishthan's Kamalnayan Bajaj Institute of Engineering and Technology under Entrepreneurship Development Cell in association with IIC Institutions Innovation Council presents workshop on IPR and IP Management for Startup. So today we have with us guest speaker Dr. Vijay Oak sir. He is assistant professor at Law College, Vidya Pratishthan, Baramati, and he, being from a law college background, has information about how to file IPR or what is meant by patent, and this information about filing a patent or about the patent or copyright or about IP management for any startup. This information can be very well obtained from a person like Dr. Oak. And on behalf of VPKBIT Baramati, I welcome you, sir, for this workshop and hope our students will definitely get as much as information and as much as knowledge from you. So I hand over this platform over to you. Please, sir, start with your session. Yeah.
Okay, thank you very much, sir.
Yeah.
At the outset, let me say sincere thanks to Dr. Bitskar sir and also Professor Sheikh sir for giving me this opportunity to share my views on the topic of IPR and IP management for startups.
Yes.
Now, to begin with, it is very important in modern days that one should have a very strong IP portfolio. It may be a startup or even any form of business organization. The strength of the IP profile is very important. And therefore, each and every organization, it shall try to enforce and protect its intellectual property. And therefore, this particular topic of intellectual property has assumed great importance in recent times. So to tell you the outline of my presentation, firstly, I will introduce the theme. Then we'll have a glance at the nature of intellectual property. Then we'll briefly go through the classification of intellectual property. And then we'll come to the core intellectual property rights, that is patent, trademark, and copyright. But besides that, we will also be dealing with some other properties like industrial design, and we will also go through the concept of geographical indications. So this will be the outline of my presentation, and one by one we'll go through all these important themes in today's presentation. Now, initially we'll see what is the general coverage of intellectual property. Now, as far as intellectual property is concerned, it is not a traditional type of property. Traditionally, we understand property as either movable property or immovable property. But there is one more property, that is intellectual property, and it is a non-conventional type of property. Because this property, that is intellectual property, it essentially requires the application of the human intellect and also the hard work on the part of its creator. And therefore, intellectual property is quite different from our traditional form of property, because the traditional form of property may or may not require the application of the intellect, but intellectual property always requires the application of human intellect or the talent, coupled with the hard work or hard labor. And therefore, intellectual property differs from our traditional form of property. Now, intellectual property is broadly speaking, it can be in the form of patent sometimes. Sometimes it may be in the form of trademark or copyright, or sometimes it can be a kind of industrial design, or sometimes it can be geographical indication, or even trade secret, or the farmers' rights are also recognized in respect of the new plant varieties. Similarly, if we go to countries like Japan or Taiwan, then semiconductor integrated circuit patents have also been very well be catching up in those countries. And in India also, the lot of research is there on the topic of semiconductors. And some patents are there even in the field of semiconductor integrated circuit. And that is the broad coverage of intellectual property. And this property is important for scientists as well as designers, including the fashion designers, authors, film producers, music composers, and even the organizations. It may be the company or maybe university or even the college, because as we all know, that even the NAC ranking depends a lot, or the ranking in other accreditation council also depends a lot on the intellectual property portfolio. And that's why this has become very crucial even for the educational institutions. So this is about the introductory aspect of intellectual property. Now let us come to nature of intellectual property. Now, intellectual property is more a kind of negative than positive type of property, because the main object of protection of intellectual property is to prevent the others from copying the original work or from doing something without the consent of its creator. So the object is negative in nature instead of the positive. And therefore, it is said that intellectual property is generally a negative in its form rather than positive, because the person who has created something original, that person, he wants to protect his creation, and that's why he wants to prevent the others who are trying to impinge upon his creation. And that's why it is more negative than positive type of property. Further, intellectual property is essentially territorial in nature. It means if my patent is registered in India, then I can protect it in India. And if its violation takes place in some other country, and if I'm not having the registration in that country, then I may not be able to effectively protect my intellectual property in that other country. And therefore, now the patent can be obtained even at international scale under various types of procedures like the Patent Cooperation Treaty or PCT procedure. And then only we will be able to effectively protect our patent if it is registered in the other countries also. Now, it has been made possible that simultaneously we can get registration in a number of countries. And that's why it is very much possible that we can protect our intellectual property in our own country as well as in the other countries. And by way of single application also, in some of the countries, we can register our patent or our trademark or even copyright. So that has been made possible at international level also. But it is to be kept in mind that intellectual property is always territorial in nature. Territorial in the sense that your intellectual property will be protected subject to your registration. So if my intellectual property is registered in India, then I'll be able to protect it within the territory of India. And for international protection, I will require the international registration also. And hence it is said that intellectual property is essentially territorial in nature, and it is always limited by territory. Then let us come to the classification of intellectual property, which has been recognized by the World Intellectual Property Organization. And you can see in this slide number of intellectual properties I have mentioned here, and which I have said in the previous slide also. The core intellectual properties, they include the intellectual property of patent, trademark, copyright, and design. These are the core of the intellectual property regime. But beside that, plant varieties patents are also there. Geographical indications can also be registered, and trade secrets and confidential information can also be protected. So all this is the classification of the intellectual property, and this classification has been recognized by the World Intellectual Property Organization, or what is known as WIPO. So WIPO has given recognition to all these different forms of intellectual property rights. Now, one by one, we will discuss these properties, but the patent will remain the main focal theme, because patent is considered to be the most important intellectual property. So by the word patent, actually we mean that it is a kind of monopoly right, and it is given to that person who has invented a new product or a new process. But since it is a monopoly right, it is an exclusive right given to that person only. It is given only for a limited period, and that limited period happens to be 20 years from the date of application for registration. So from whichever date, or on whichever date the application for patent has been filed, from that date of application, you have to count 20 years. And the protection will remain only for a limited period of 20 years. And thereafter, the said invention will go into public domain. And then there will be no infringement as such, or no violation as such of that patent. Because the validity period is 20 years. And what happens after 20 years is that it becomes a public property and it goes into public domain. So later on, after 20 years period comes to an end, we won't be able to protect the patent, because patent is confined only to a period of 20 years. And patents are generally recognized as product patent and process patent. So most of the patents which we come across, they are generally the product patents. But apart from products, sometimes the processes can also be patented. So even the process can be the subject matter of patent. So for example, there may be some process in biochemistry, or maybe a process in chemistry, and that chemical or biochemical process, it can be patented, and its patent will remain valid again for 20 years. So the law does not discriminate between validity of product patent and the process patent. Both of them can remain valid for the similar duration of 20 years. And generally, two important theories are advocated regarding the grant of patent by the government. And the first theory is known as the reward theory, and the second theory is known as the incentive theory. Because the person who makes some invention, by application of his talent and application of his intellect or application of his brain, if a person has made some invention, maybe of product or process, then that person must be rewarded by the government. And as a kind of reward, only he is given the exclusive right to manufacture the patented product or to manufacture and sell the patented product. So that right is given only to that inventor, and that's why it is called as a monopoly right. And when that monopoly right is given by the government, then that monopoly right, it is nothing but a kind of reward which is given, or it is also known as an incentive which is given by the government for making new and better inventions, because that person can get commercial gain by using that monopoly right for a period of 20 years. And 20 years period is considerably a long period. If only one person is given the right to manufacture and to commercially sell the invention for a 20 years period, then that person can obtain huge profits. And that's why it is a kind of reward, or it is a kind of incentive which is given to the inventor. And that's why patent is very important intellectual property in modern times. Now let us come to some essentials of the grant of patent. That is, if any person wants to obtain the patent, then which essential conditions he must satisfy. The first is known as novelty, second is utility, and the third one is non-obviousness. Now, one by one, we'll see what is the meaning of each of these essential for the grant of patent. So first one is novelty. Novelty means you have to establish in the patent office that your invention is a new invention and it was not previously used by anyone, or it was not previously published in any document, that is a scientific document or in a journal or in some magazine. So it means your invention should not be anticipated already. And if it is already published in some scientific journal, or if it is already in public use, then that is to be a new invention, or it will not have the essential of novelty. And therefore, it is necessary that when you apply for the grant of patent, you must show that there is a novelty in your invention. It may be product, it may be process, but it must possess the essential known as novelty. And if that particular process or if that particular product is already published somewhere or it is already used, then you cannot say that there is a novelty in that invention. And patent office also conducts the international search to find out whether your invention is already patented or your invention is already published. For that purpose, they can carry out the international search of the awarded patents. And from that, they will come to know whether already some patent in some country has been granted to the invention for which you have applied for the patent. So it must have the essential of novelty. Then one more essential of grant of patent is known as utility. And the word utility here means usefulness, or it means the industrial application. So you should be able to show that the product which you have invented or the process which you have invented, that product or process that has got some industrial application. It can be beneficially used in some type of industry. And if you can show to the patent office that you can use that invention in the industry, then only it will be said that it is having the utility or it is having the industrial application. So industrial application or the utility is also a very important essential for the grant of patent. That is the second essential requirement. And one more is there, which is very difficult to prove, that is known as non-obviousness. Now, in this requirement of non-obviousness, what you have to establish in the patent office, you have to establish that your invention is unknown even to the experts in that field to which that invention belongs. So, for example, your invention is regarding the field of, let us say, instrumentation engineering, or your invention is, let us say, in the field of mechanical engineering, then you have to establish in the patent office that this invention is unknown even to the experts in the field of instrumentation engineering or the mechanical engineering. That is, even the most expert people in that field, they also have no knowledge about such invention. Then only it can be said that your invention is non-obvious. Non-obvious means it is unknown even to the experts. Now, the slight distinction between novelty and non-obviousness is that in novelty, you have to establish that your invention is not known to the common people. But in non-obviousness, which is still a more difficult test to pass, you have to establish that your invention is not known even to the experts in that particular field to which the invention is related to. And if you can show to the patent office the essential that your invention is having novelty, your invention is having utility, and in addition, it is also having non-obviousness, then you can show to the patent office that your invention is eligible for the grant of patent. Then only they will proceed with the granting of the patent. Now, as far as all these essentials are concerned, these essentials are always applied by the officers in the patent office. And whenever any application comes to them, the examiners are there. Those examiners will first try to find out whether novelty is there or not. Then they will see whether the invention for which the patent is sought by the applicant, whether that invention can be applied in any type of industry, and whether that invention is known to the experts or not. And if all these requirements are satisfied, then only the patent, it can be granted. Now let us turn to next slide. Okay, now what is the procedure for a prosecution of patent in India? Now, as 1970, so separate law enacted by the Parliament of India to regulate the grant of patent. And in that particular legislation, the Parliament has prescribed the detailed procedure of obtaining the grant of patent from the Patent Office of India. Now, the first stage is known as the stage of application. So this application, it shall be made in prescribed form and along with the prescribed fees. Now, depending upon the nature of the patent and the person or the organization who is making an application, there may be some difference in the fee which is payable. So that fee we can come across in the patent rules. If you go through the patent rules, you will come to know the fees which are payable. And different fees are payable for the individual applicant and the organization as such, because the organization is made liable to pay more fees as compared to an individual. So individual's fee is less as compared to the fees of organization. So the first stage is known as application. Now that is to be made only to the appropriate patent office. Now they have established the regional patent offices, and depending upon our region, we have to make the application to the proper patent office. For example, if we are all the residents of Western India, that is, we come in Western part of India, that's why we will have to make the application to the Mumbai patent office. If some person is from South India, then that person will have to make the application in the Chennai patent office. And accordingly, they have established the office at Delhi also. They have established one more office at Kolkata for the people from eastern states in India. They have to approach the Kolkata patent office, and depending upon the region, we must file the application only to the appropriate patent office. And in that application, also we have to mention the statement, and in that statement we have to say that the invention is made by the applicant and that particular invention is eligible for the grant of patent. And along with the application, one important document we have to file to the patent office, and that is known as the specification. Now, in the specification, which is a very important document and for which the help of the patent agent is to be taken, it is very essential that along with your application, you must file the specification. Now, this specification may be of two types. First can be the provisional specification, and the other can be the complete specification. So provisional specification is a very important document because it will give you a preferential right over the other applicants. So for example, let us say your invention is complete, but it is only 80% completion, and you have not made 100% completion of the invention, and you are in the process of completing that invention, but still you have worked out only 80% of the invention. Then you can file the provisional specification. Even though you have not completed your invention, because number of people are working on the same invention at the same time, it is very important that you first should file the provisional specification. And at that time, your invention may not be a complete invention. You are on the way to complete your invention. Some part you have completed and only some part is remaining. But at that point of time also, you can file the provisional specification and the application. Now, the rule in Patents Act, which they have given, it says that if you are filing the provisional specification with the application, then you will get 12 months period to complete your invention. So the patent office will give you 1 year, and in 1 year, you will have to complete that invention, and then you will be required to file the document known as the complete specification. Because now it is not provisional. Now you have completed your invention within a time limit of 12 months, and now you have to file a complete specification. Now, if we see the format of the complete specification, that shall give certain important points in that complete specification. First is you should mention the title of your invention, whatever may be the title of the invention. Suppose it is some kind of machine. If we are talking in terms of, let us say, instrumentation or the mechanical engineering, some machine is invented by a particular student or a particular teacher. Then you give the title to that machine. Then you mention the scope of your invention, whether your invention is in the area of, let us say, engineering, or it is in the field of pharmaceuticals, or it is in some other field. So that field you have to specify, and that will be called as the scope of your invention. Then one more important point you have to mention is the claims which you are going to make. So whether you are going to make claim, for example, on suppose your invention is mobile handset. So whether you are going to make a claim for patent only for handset, or along with that you have invented the megapixel camera also, then you can claim a patent for megapixel camera as well. And that you have to mention in the topic that is known as claims. So your claims should be clearly specified. Because if you don't make a claim on certain part of your invention, then you will not be given the patent for that particular part. So for example, suppose I have invented a mobile handset, and I have also invented megapixel camera to that mobile, but I don't claim any patent over that megapixel camera. Then the patent office will not give me the patent for that megapixel camera. It will give me the patent only for the handset. And therefore, claim is a very important aspect of that application. And therefore, you should take the help of the expert patent agents in order to draft the specification. Because your entire application and the merit of your application is decided on the basis of that specification. So it is the most crucial document which you have to file. Then after you file the application, if the application is found to be correct by the patent office, and if the specification is also filed with that application, then you have to make request to the patent office to publish that application along with the specification. So that request you have to make to the patent office for the publication of that application. Then your application for that particular publication is received by the patent office. You have to pay certain fee for publication, and then that particular application along with the specification, it will be published by the patent office in the official gazette. So there is an official gazette of India, and in that official gazette, the particular invention for which you want the patent, that specification of that invention and the application, that will be published. So that stage is known as the stage of publication. Now, why publication is important? Because if any person wants to take the objection for the grant of patent, that person should be in a position to take the objection. That person may take the objection that already that invention has been patented in his name. So again, you cannot give the patent. So you can take the objection that already that invention is patented in my name. So you cannot give one more patent for the same invention. Or maybe the objection can be taken that it is lacking the novelty. Already some people have used that invention, or already that invention is published in some scientific journal, or it is published in some document. That objection can be taken. Or sometime the objection can be taken that there is no utility involved in that invention. There is no industrial application of that invention. So on number of grounds, the objection can be taken. And that's why publication is very important stage in the entire patent prosecution process. Then you have to make the request to the examiners that you please examine whether my invention is patentable or not, whether it is eligible for the grant of patent or not. Then the examination will be done by the examiners in the patent office. These are the special officers, and those officers will examine your invention. So what they will check in that invention, they will check whether it is having novelty, utility, or it is non-obvious or not. They will call some expert also, and that's why you have to pay they have to spend on the experts fee and all that. That's why some expert in that field will be called, and he will be asked whether he knows about such invention or not. Because you have to prove that your invention is non-obvious, it is unknown even to the experts. And that's why you have to the request for examination. This examination is of two types. The first examination is known as a formal examination. Second is known as a substantive examination. Formal examination is quite easy of examination. They only check whether your application is in proper form or not, whether you have paid the proper fee or not. So only that much is checked in the formal examination. But in substantive examination, they will go into the merit of your invention. They will check everything. They will carry out the international search of already granted patents, whether same invention has been given patent elsewhere, not only in India, but in other countries as well. So that will be checked by them through their patent search engine. And then only they can express the opinion whether your invention can be granted the patent or not. So that stage is very important stage. And after conducting the examination, the examiners, they have to prepare a report, and that report shall be submitted to the head of the patent office. And that report may be either a positive report or it may be negative report. Whatever type of report is there, the examiners have to submit that report to the head of the patent office. And depending upon the type of examination which was carried out and the type of findings which have been given, then they will proceed either with grant of patent or the refusal of patent. Because if the examiners are of the view that your invention is already patented and there is no novelty in your invention, then they will make the report that this invention is not eligible for a grant of patent or no patent shall be granted. And if their report is positive, then only the grant of patent will follow. But if has taken the objection. Suppose some person has raised the objection that your invention is lacking novelty because that invention is already published in some scientific journal. Then the patent office will conduct the hearing of both the parties, just like court. Both the parties will be called before the patent authorities, and both the parties are to their own case. The person who is taking the objection, he has to prove, if his objection is that there is no novelty in that invention, then he is asked to prove why there is no novelty in the invention. And accordingly, both the parties are given equal opportunity of hearing by the patent office, and then only the patent office will decide whether to grant the patent or not to grant the patent. And then after the patent is granted, the person who becomes the patent holder, or what is called as patentee, he will have to pay the renewal fee. So renewal fee is also payable, and on payment of the renewal fee only, the patent can be renewed. And it can remain valid for a total duration of 20 years. But this span of 20 years is to be counted not from the date of grant of patent, but it should be counted from the date of application for the patent. And entire procedure may take around 1 or 2 years also for the grant of patent. So even if your patent validity is 20 years, if you lose 2 years in the entire procedure, then what you get is only 18 years, because the period is to be counted from the date of the application and not from the date of granting of the patent. So that is about the procedure which they have prescribed in the Patents Act of 1970 about the prosecution of patent. Now, some of the patented inventions I have mentioned here, and the source also I have mentioned. This was taken from one of the applications and a complete specification filed with the US Patent Office. And this particular entire machine, it was patented, and actually it was a part of the aeroplane. So that was patented invention, and it was patented in the US Patent Office. So when you file this complete specification, this type of drawing also you have to submit. If there is any drawing of your product, then that drawing shall be submitted, and it will generally look like this particular diagram. So generally that type of complete specification you have to file once you complete your invention. Or here you can see again from the US Patent Office, the sewing machine, it was patented, and that particular patent was granted on October 13th, 1885, long time back it was granted. So in that specification also, the drawing of that sewing machine, it was submitted. So you can see figure 1 and figure 2 in this particular slide. So along with the application for the grant of patent, this particular drawing was submitted in the complete specification. And this is one more invention, very important invention of that time, 1897 invention. It was by Richard Ulick, and it was a typewriting machine. So at that time, the typewriting machine was looking like this. So the drawing was also submitted as a part of the complete specification, and then the search was conducted, and then the patent was granted. So this was from the US Patent Office. And most of the inventions you will see, they are from the field of engineering. Many of them are from engineering. And this is one more type of patent which can be granted, that is of semiconductor integrated circuit. So some of the countries like Japan and Taiwan, they have made huge progress on account of number of patents which they are holding for the semiconductor integrated circuits. And if the semiconductor integrated circuit is of very novel type and it is having industrial application, then it can also be granted the patent. So semiconductor integrated circuit is also an important area of the research in the modern times. And semiconductor patents have been granted Semiconductor circuits are used in number of equipments, you can say, or whatever electronic equipments are there. In most of them, we use the semiconductor integrated circuits. And for those semiconductor integrated circuits, number of patents have been awarded. So all these gadgets, they are based upon the semiconductor integrated circuit. Now, if we see the top technology areas for the Indian innovations during the period 2016 to 18, we'll come to know that some of the areas have remained very important, and they are the top technology areas. So the most important technology area you can see it's computing, because a number of innovations have been made in the field of computing. Then polymers and plastics and communications, they are almost equal, and highest one is about the computing, then polymer and plastic and communications, and then comes pharmaceuticals. Then you can see slight variation is there. Then there is a decrease in the number of innovations which are taking place in electric power engineering, then food, water and biotech, chemicals and chemical engineering. Then here you can find about the instrumentation and test and measurement. So instrumentation engineering also has got some significant amount of innovations and research going on. Then automobile and aviation is almost same like instrumentation, and then semiconductor. In India, still it is picking up, but in country like Japan, it is the highest patent earning technology area. But in India, the top technology area remains the computing, the field of computing. And the source I have mentioned, Derwent Innovation, they have given this particular statistical data for the period ranging from 2016 up to 2018. Now here you can see a news from Hindustan Times where they have mentioned that Chandigarh University has made a national record in the field of research, and it has filed 500 patents in last 7 years. So number of patents have also been obtained by them, and number of applications for grant of patent have been made by them. And even IITs combined have made 557 applications for grant of patent, but Chandigarh University alone has filed 500 patents in 7 years. And combinedly in 1 year, but it is IITs have filed 557 applications for the grant of patent. And in that same year, that is in 2018, here you can see Chandigarh University had filed the patent applications, and there were 336 patent applications in the same year. So that type of research is going on even in the universities in India and in IITs, and a lot of students, they are getting the patent grant as well. So much more research is still needed in comparison with US and China. We are still nowhere, but still it must be said that our student fraternity is doing quite well in recent times, so far as the IITs are concerned, or a university like Chandigarh University is concerned. And even I think even Kamal Nayan Bajaj Institute has also got some important patents. So it's up to you students that you can increase this particular number, and by your talent and by your intellect and hard work, this can be achieved, just like Chandigarh University. Now then, many times it happens that there is a violation of the patent. It means, suppose the patent is registered in the name of A, then without his permission, another person like B or C, they are manufacturing that invention and they are selling that invention without his permission, without his consent. Then that will constitute what is known as infringement of the patent. That is the violation of the patent rights. So if the patent rights are violated, then that particular violation of the monopoly right of the patentee, it is known as the infringement of patent. Because once the patent is awarded to a particular person, then only that person can manufacture the invention or he can sell the invention. And if it is not possible for him, then he can give the permission to some other person. But without the permission of the patent holder, if some other person starts manufacturing and selling that invention, then it will constitute the infringement of patent. And if the patent has been infringed, then the remedy which is available to the concerned person is to file the civil action in the civil court, or also to file the criminal action. So he can go to the civil court, he can claim compensation for the violation of his exclusive right of manufacturing and selling. He can claim compensation or damages from that other person who has committed violation of his patent rights. Or even criminal action is possible, because infringement of patent is a kind of criminal wrong. It is an offense. And since it is a punishable offense, even the punishment like imprisonment, it can be given to such infringer. So these remedies are made available under the Patents Act of 1970. Then let us come to trademark, because when startup is there, then in most of the cases, the business of the startups, to a great extent, it depends upon effective protection of their trademark. So trademark is very important even for startup and even for other business organizations. So what is the meaning of trademark? Trademark, it is a kind of mark, and it is capable of graphical representation. It means you should be able to draw that trademark on a piece of paper. And if you can draw that trademark on a piece of paper, then we can say that it is having a graphical representation quality. And it should be able to distinguish the goods and services of one person from similar goods and services of another person. So, for example, the goods of Nike should be distinguished from the goods of Adidas. And for the distinction purpose, you can use the logo or you can use the trademark. And that is the precise function of any trademark. Then I have given various forms in which the trademark can be there. So sometimes the trademark can be in the form of a logo. Sometimes it can be an inventive word. Inventive word means there is no dictionary meaning of that word. For example, the word Kodak. If you check any dictionary, Oxford Dictionary or Cambridge Dictionary, or any dictionary for that matter, you will not come across the meaning of Kodak, because it is an inventive word. It is very much invented word. And that's why inventive word should be there, and that inventive word can be used as a trademark. Or sometimes the numeral can be used. So some companies, they use some number as their registered trademark. For example, there can be a registered trademark like 555, 555, 777. They have been registered as the numerals, as trademarks. Or some celebrity signatures can also be used as registered trademark. And Mr. Amitabh Bachchan's and Lata Mangeshkar's signatures, they are being used by the French perfume company, that is Lomani, as their registered trademark. Because of the huge popularity or immense popularity of Mr. Bachchan and late Lata Mangeshkar, they have used their signatures as the trademarks. And some film companies or entertainment companies are using the sound mark as the registered trademark. So you must have seen in Hollywood movies also that lion is there. So that particular lion sound has been registered as a trademark. And in some countries, even the smell marks have now been recognized. So smell marks are not capable of graphical representation, but even the smell can be registered as a trademark in some of the countries. And this trademark, they help us in effective advertisement in very lesser space, because very less space is required. And in that less space also, we can effectively advertise a particular product, and we can create a brand image of that particular product. And that's why the trademarks are very important type of intellectual property. Now here I have mentioned very famous trademarks, which you all must have seen somewhere. And I need not tell what is the trademark of which company. You can easily identify them. They are very famous, very popular trademarks. The trademark of Nike here you can see. The trademark of Apple you can see. Then McDonald trademark is there. So sometimes even the letter is used as a registered trademark. Nike is a kind of logo of a hockey stick, or it is a apple with some slight cut is there. So this apple is also a registered trademark. And here the signature of Mr. Amitabh Bachchan is there. And it is the registered trademark of the French perfume company, Lomani. So different types of trademarks are there. Now, sometime under the trade malpractices, sometimes very similar trademark is used by the competitors. And to deal with those competitors who are using some bad business tactics, the concept of passing off has been given. And concept of passing off, it means a particular person is trying to pass off his goods or services as the goods or services of some reputed trader or reputed company. For example, in this particular slide, you can see the registered trademark of Starbucks coffee is given, and another company has used very similar, deceptively similar trademark, that is Starbung coffee. So if the customer is in hurry, that customer may consume the Starbung coffee thinking that it is Starbucks coffee. It is not Starbucks, it is Starbung. So they are trying to cash on the reputation of the famous company, that is the Starbucks coffee. And for that purpose, they are using very similar trademark, but it is a different trademark, but it sounds similar and it spells very similar. Their spelling is also very similar and their pronunciation may also be similar. And that is known as the visual similarity, which is visual deceptive similarity, or there can be the phonetic deceptive similarity, because the pronunciation may also be same and the spelling or the appearance or the getup of that trademark is also very similar, which can cause cheating of the consumers or which can cause deception of the consumers. So the concept of passing off is also there. And if one person has passed off the goods of some reputed organization or reputed company, then we can always ask for the damages or we can ask for the compensation against that company. And that's why they have given the concept of passing off of the trademark, which is also an important concept for protecting the intellectual property right in the nature of the trademark. Now then, let us turn to one more important intellectual property, that is copyright. Now here in this slide, I have mentioned what is the subject matter of copyright. Copyright can be given for literary works. It can be given for dramatic works, artistic works, musical works, film, as well as the sound recording. Now, literary works have nothing to do with literature. We think that literary means something like novel only, but it includes novel. But apart from novel, it can even include some ordinary work like the timetable of railway, or it may be a telephone directory. It can also be protected under the Copyright Act. Or if any person has compiled a directory, so that directory or a dictionary, it can also be protected as a work of copyright. So literary work has nothing to do with literature. Then dramatic work or artistic works, they can also be protected as the subject matter of copyright, and even the film can be protected. And although the film is protected, one important aspect to be mentioned here is that many times we see some similarities there between two or more films, because the copyright is given only for the presentation of the idea. The copyright is not given for the idea itself. So some theme is there, some plot is there, then that theme or that idea can be used by a number of producers, and the film can be made on the same idea. For example, number of people can make a film on Shahid Bhagat Singh. You must have watched number of movies are there on the life of Bhagat Singh. So idea as such is not protectable under Copyright Act. What is protectable is the manner of presenting that idea. The other person should not copy the manner of presenting the idea. If he has copied the manner of presentation of the idea, then only it will amount to violation of the copyright. And same is the case with the musical works. So often we see that there are some remixes made of the original songs, but the remixes are slightly different in their entire texture is slightly different than the original tune. Why they keep it different type of text or different type of tuning? Because they want to show that there is some difference from the original work, and that remixes do not violate the copyright as such. So many times we think that remix is against the copyright, but remix is not against the copyright, because there is always some kind of difference maintained between the remix work and the original work. So all this is about the copyright, and copyright is also important in the field of those, that is especially the teachers and the students also, because nowadays there is a lot of problem of plagiarism. Lot of plagiarism is taking place while completing the projects, etc. Sometimes the students, they copy the material, they borrow the material from some author, but they don't acknowledge from where they have taken that material as such. And that's why whenever you are writing any project or any research paper for any journal, you please ensure that you have given the appropriate citations, because nowadays the plagiarism checks softwares are there. And that's why as a academician, we all must take precaution regarding that plagiarism, because it is a very important issue in Copyright Act, and many cases are now coming up which are on the topic of plagiarism. So the teacher as well as the students all must be very much conscious about the issue of plagiarism. And whenever we borrow someone's writing, whenever we borrow 2 or 3 lines or maybe definition, it is important that we give the appropriate citation for that. Otherwise, even the criminal cases have been filed against some of the people in the teaching field also. And that's why we have to be very much careful while writing any research article or submitting any kind of project to the college or to the university. And in doctoral research also, number of cases are now going on due to the issue of plagiarism. And you must have read in the newspapers, some of the vice chancellors are also in problem due to the act of plagiarism. And that's why we should stay away from any kind of plagiarism. You try to write your article as original as possible. And if you borrow from someone some portion in your article, please acknowledge from whom you have taken that particular paragraph or that particular portion, to avoid any action under the plagiarism law or the copyright law. So this is about the intellectual property that is known as copyright. Now, recently, the artificial intelligence is also emerging area of research. And one important copyright has been registered recently in the year 2021, that is last year only. The Copyright Office has registered a particular AI tool for a painting, and that tool is named as Raghav, and Raghav is recognized as a co-author of the copyright work. That is, some writing was done regarding the painting tool, some writing was made, and how to make the painting, etc. Some guidelines were given. And for that purpose, Raghav has been registered as a co-author. But it has been said by the Copyright Office that the artificial intelligence tool itself cannot become the author of the copyright, but it can become the co-author along with another person who has to be a human being. So only the artificial intelligence tool or artificial intelligence app cannot become the copyright owner. Some human being should be there, and along with the human being, the artificial intelligence tool can be called as a co-author of the copyright work. Then what are the rights of the author of copyright? So number of rights are given to the author of the copyright, like to reproduce the work. It means if I have written some book, then I can decide how many copies of that book can be reproduced. So that decision rests entirely with that author. Or I can distribute, or I can decide how many copies can be distributed of that work. So I may reproduce the copies, but I may not distribute. So that is entirely the decision to be taken by the author of copyright. Or if I want, I can have a public performance of that copyright work. So some public performance can also be there, and that copyright work, it can be performed in front of the audience or in front of the public. So that right is also given to the owner or the author of the copyright. Or I can broadcast that particular copyright work. So for example, I have written a novel, or let us say the novel was there written by Chetan Bhagat, that is 2 states, and later on it was made into a film. So he had given the copyright to convert it into a film to that producer of the film. And that's why you will find that there is a novel 2 states, and later on that novel is adopted in the form of a film. So it can also be done. Then sometimes the commercial rental is possible, and sometimes the communication of that work by wireless medium or by wire is also possible. So if I want, I can give my copyright work on a rental basis to someone, and I can collect the rent from that other person by giving my work to that other person. But it is not that I have sold that work. I have given it only on a rental basis, and I can collect the rent by giving it on commercial rental. So all these various rights have been conferred upon the author of the copyright. And if without my permission, suppose someone has taken or made the copies of my work, or they have made a certain number of copies and distributed them among some people and earned a profit, then I can file the civil suit as well as I can file a criminal complaint for that copyright violation. So if without my permission, if my work has been copied or it has been sold to the public, then I can always take the legal action against that infringer. But there are some exceptions, like we can use the copyright work for an educational purpose. So we are using textbooks or recommended books for teaching in the class. That does not amount to violation of the copyright. So if we can show that we are using it for the purpose of education and not for making profit or commercial gain, then we can say that there is no violation of the copyright. Or sometimes some type of copyright work may be required by the court of law for the legal proceeding. When some case is going on in the court, they may require some copyright work as a kind of document in that particular case. Then they can also use the copyright work, and it is a kind of exception given to the copyright infringement. And sometimes the Parliament of India or any state legislature may require a copyright work for the purpose of discussions in the parliament or in the legislative assembly. Then that will also not constitute the violation of the copyright. So some defenses are also given in the Copyright Act. If some person files a case against us for violating the copyright, then we can take some of these defenses, and these are known as the doctrine of fair use. So if we can show that we have not made the illegal use of that copyright work for the commercial profit and only for the educational purpose or for judicial purpose or legislative purpose, then that will be taken as the fair use of that copyright work. And it will not constitute violation or the infringement of the copyright. And one more property is there, industrial design. So sometimes some new type of shape is invented, some new ornamentation of a jewelry is invented, and that can be registered as a design. And even the concept of design is made applicable, or the design rights are given even in respect of the fashion design. So number of cases are there involving the fashion designers, because many times the fashion designer lift the ideas from another designer, and some cases are reported regarding the fashion designing field as well. So the design, it must have a visual appeal, and only by looking at the appearance of that particular design, the customer should take the decision to purchase that product, even though he may not need that product. So for example, suppose you are having some car with you, but some new car comes in the market and it is having much better look and much better appearance. Now you are already having the car, still you will purchase that another car. Why you will purchase? Because its appearance, its pattern or its shape has a visual appeal. And although you don't require the car, still you will decide to purchase that car because it is having a visual appeal due to its registered design. And many car companies, they register their design under the Designs Act of 2011. So Designs Act is a separate law or separate legislation under which the new type of design, if it is applied to a known product, that design can be registered. And if other person copies that design without the permission of the owner of that design, then again the case can be filed for the piracy of the registered design. Because when your design is used by another person without your consent or permission, then that is known as the piracy of design. So just like in film industry, there is a piracy. In case of design also, instead of infringement, they use the word piracy of the design. And against that piracy, again, you can go to the court of law and you can claim compensation from the court of law. So this is about the industrial designs, and they are also becoming very important property because you can increase your customer base and your profit depending upon the novelty of your design or the pattern, or in the field of jewelry, the ornamentation of that jewelry. So this is about the industrial designs. Then one more intellectual property is there, that is geographical indication. So some products or some manufactured goods have got the better quality because of the climate in a particular locality or the climate in a particular region. And therefore you can register it as a geographical indication. And number of famous geographical indications are there. Darjeeling tea, then Simla apple is also there, which is a registered geographical indication. Banaras silk is there, and Paithani is also there. And number of other geographical indications are also there. So for example, suppose a person who is a manufacturer tea in Baramati, if he makes a package and he prints on that Darjeeling tea, and that tea is manufactured in Baramati and he sells it as Darjeeling tea, then that is the infringement of the geographical indication, because that person is trying to show that the tea is manufactured in Darjeeling and actually it is manufactured in Baramati. Then that will amount to infringement of the geographical indication. Or Banaras silk, which is a very famous geographical indication, and Paithani is also very famous or popular geographical indication, which is registered with the GI office of India. So Paithani is manufactured in Paithan. Suppose some person manufactures Paithani in Baramati and label it as Paithani, then it is not a Paithani because it is the violation of the geographical indication. Because you are trying to show to the customer that this comes from Paithan, but actually it has come from Baramati. Then that will amount to infringement of that geographical indication. And geographical indication is not registered in the name of single individual, but it is registered in the name of group of people or the association of people in that particular region or locality. So for example, Banaras silk, this geographical indication is used on those silk sarees by the people only from Banaras. So whichever people are from Banaras and who are the manufacturer of Banaras silk sarees, only they can use the geographical indication Banaras silk, and other people are prohibited from doing so. Same is the case with other geographical indications. So from the name, it gives some clue about the geography. That's why the name is Darjeeling tea. So it is from Darjeeling. Or Simla apple, it is from Simla. Or Banaras silk is from Banaras, and Paithani is from Paithan. And that's why some clue is given in the name itself about the geography or about the region. And then what is the relevance of intellectual property for the startups? It can be said that all the types of intellectual properties are going to be crucial for startup businesses. And if they can effectively protect their intellectual property, it may be a patent, it may be a design, it may be trademark, or it may be their copyright. If they can protect their intellectual property in effective manner, then only they will be able to earn the huge revenue. Otherwise, some person will use their trademark and that person will cause them great loss. Or if they have invented something new, if some startup is there and they have made some new product, and their product is patented by some other person, or their product is patented by them, but it is manufactured and sold by some other person, then that other person has the potential to cause them great revenue loss. And that's why the startups, they will suffer a heavy loss if they fail to protect their intellectual property rights. And that's why it is very important for startup businesses that they must take quite important steps in order to effective protection of their intellectual property rights, which may be in the nature of patent, trademark, copyright, or sometimes it may be design as well. So I think I have concluded with my session. If any questions are there, you may coordinate and ask the students for any queries or the questions.
Sir, I myself have one query.
Okay.
Sir, while we write the inventory disclosure before provisional application of file, so is it required provisional means is it required to write the inventory disclosure, or is it not required?
Actually, inventory disclosure is not mandatory per se, because inventory disclosure is only optional type of information which you have to disclose. But I have seen that many applicants, they actually give that inventory disclosure, but it is not mandatory upon you to give that disclosure.
Okay. Sir, second question is, can we go directly for complete specification filing? Means skipping provisional filing without provisional filing?
Yes, yes. You can go for complete also, but one danger is there, that if some other person was already working on that, then you won't be able to book your invention.
Okay.
Suppose in your same institute, suppose 2 or 3 researchers are working for the same invention, or maybe in some other company, some researchers are working for the same invention, and they have filed a provisional specification. Now, if they have filed a provisional specification and you have not filed, even if you complete before them, you will not be given the patent. So that's the risk that is involved in not filing the provisional specification.
Okay. So anyhow, if we go for provisional, also the time will be required for going for publication will be same. Means I was thinking like that, if we go for direct complete specification, the time which is required for provisional, that can be minimized, and like we can directly go for the publication. Means the time required will be less. But as you say, provisional filing is important, right?
Yes, yes.
Sir, one more thing. There is some particular thing that is express way of going for examination. Is there any such way for going for the grant examination in less time? Means, I have just heard for it that we can go for that examination, grant examination, within some less time.
Yes, now actually the procedure is that you have to make them the request that you please examine my invention. And in that application, you can tell them that I need urgent examination.
So is there any fee for that?
If you mention that you require urgent examination,
okay,
then they may allow that also.
Is there any extra fee required for that?
Yes, for that you will have to pay extra fee for urgent examination.
I request other participants, if you have any doubts, you can ask. Okay, sir. So should we move towards our conclusion?
Yes, sir. No problem.
Yeah. So it was a fantastic session, sir. You have given very good information about patenting and filing. It was a deep, in-depth information. Like this information, we cannot have it from any other resource person. Means you, as a professional, means as a lawyer, you have also told us the other side of the coin, what is related with criminal and civil cases. So that is one important thing that a person should know before filing of patent, right?
Yes,
So,
exactly. Yeah.
sir, thank you so much. I hope participants have also filled the feedback forms. If not, they can still fill it. It's there in the chat box. So on behalf of VPKBIT Baramati, and on behalf of Institute of Innovation Council, IIC, I thank you, sir, for coming and all the way from your hectic schedule. You have given us a time and given this presentation. So thank you very much, sir. I declare that the session is over. Thank you, sir.
Okay. Yeah. Thanks.